Good morning, everyone, and welcome to the New Possibilities Hour, September 17th, 2020. This is part of the Will Work for Food project, where we bring you these webinars, very valuable webinars free of charge, and we ask you to contribute to a food bank if you like what you see. Natalie, I believe we've hit over $52,000 raised so far for food banks worldwide. You want to update us, please?
You bet. I love giving these updates. Jeff, we're at $52,400 in donations from the ADR and legal industries for food banks all over the globe.
Unbelievable. Well, thank you all the people who watch these webinars and contribute so generously. Our special guest today is John Kiernan. John has been a full-time litigator and occasional mediator and arbitrator for 40 years. His home base has been the New York headquartered international law firm of Debevoise and Plimpton, where he has been a partner since 1988, a member of the management committee, and for 15 years, co-chair of the litigation department. John's involvement with ADR has included not only participating in a large number of mediations and arbitrations as an advocate, but also longtime membership on the board of the International Institute for Conflict Prevention and Resolution, popularly known as the CPR Institute, where he has been the only practicing litigator ever to serve as board chair and has been significantly involved in cutting-edge thinking about enhancing ADR. John was president of the New York City Bar Association 2016 to 18, where he formed a president's task force on enhancing efficiency in dispute resolution. He made thinking about how to improve dispute resolution a centerpiece of his tenure. Following appointment by New York State's Chief Judge Janet DiFiore in 2018, he chairs a statewide ADR advisory committee in New York that has advocated for sweeping increases in court-sponsored ADR as a vehicle for making dispute resolution cost less money and take less time, and for giving litigants more personal agency in resolving their disputes, as to which the Chief Justice has responded by stating publicly that the state judiciary is all in and initiating a massive movement for early automatic mediation of disputes. John has also written and spoken extensively on advancing ADR, including in a 2019 article in the Cardozo Law Review. Apart from work in advancing ADR, John has also been significantly involved in working to deliver legal services to people who need them but cannot afford them. Over his career, he has chaired the boards of Legal Services New York City, the Lawyers Committee for Civil Rights Under Law, Volunteers of Legal Service, Prisoners Legal Services of New York Times and the Justice Resource Center, and has served on multiple other boards or commissions, including New York's Permanent Commission on Access to Justice. John has also served as mayor of his suburban New York community. And John is a member of the class of 1980 at Harvard Law School. And because John was so generous in sharing class notes with others, I was also able to manage to graduate as a member of that class. So to my longtime friend, John Kiernan, welcome, John. The floor is yours. Maybe start by mentioning the food banks that are important to you and to which you'd like to see people direct contributions.
Well, thanks, Jeff. And if people are so minded, two great food banks in my neck of the woods are City Harvest NYC and Feeding Westchester, both great organizations who do great work. And as Jeff confessed, we are longtime pals. We knew each other back when, and I'd like actually to dedicate this webinar to the memory of a beloved classmate of both of ours, Ralph Gantz, who died this week. Ralph was the Chief Justice of the state of Massachusetts, but long before that, when he was just a kid we knew, he was already destined to be a person who dedicated his life to use of the law to improve the lot of mankind. And he's really an exemplar of why we went to law school, what can be done. He's a great man, and I'd like to dedicate this to his memory.
Amen.
So it's a pleasure to be talking to this collection of mediators from all over the world. from Jeff's description of this group, it sounds pretty clear that this is not a group that needs to be persuaded of the value of ADR as a vehicle for resolving disputes. You've been walking that talk, many of you, for decades. Instead of preaching to the converted on the basic value of ADR and particularly of mediation, I thought in the spirit of thinking about new possibilities, I'd spend a few minutes today talking about where mediation and other forms of dispute resolution seem to stand in their evolution. So let me suggest two basic propositions that may or may not be controversial with this group. First, over recent decades, the dispute resolution world has witnessed really a tremendous movement away from the notion of the jury trial as the fundamental mechanism for resolving disputes that people are not able to resolve by themselves, and toward a recognition that there are other and better ways available of resolving disputes. If you go back 40 years when Jeff and I were just coming in our diapers out of law school in 1980, a significant percentage of civil disputes at that time went to trial, and mediation, more significantly, was almost unheard of. Reserved really for extraordinary multi-partite circumstances or attempts to negotiate treaties, and really rejected largely by most litigators on the basis that mediation reflected weakness among a group of people who considered themselves anything but weak, and that a mediator would be unlikely to be able to achieve results that the litigators couldn't achieve through good old-fashioned toe-to-toe and nose-to-nose negotiations with their counterpart on the other side. Now today, as the presence of this group in a community of ADR professionals with steadily increasing numbers and scale attests, mediation, arbitration, and other forms of ADR have become an important part of really the standard fare of commerce. Agreements between sophisticated parties provide with increasing frequency that the parties won't litigate against each other without exhausting mediation efforts first, and I can tell some anecdotes about that later. And they often provide for highly streamlined procedures, even if apart from mediation, for arbitration or litigation if the dispute continues to a point where a decision is needed about who wins and who doesn't. Courts are also increasingly considering ADR part of their business, having long thought that this was a separate world that they operated in a different frame from, and are increasingly referring parties to different forms of ADR when they believe that particular disputes are better resolved through neutral directed negotiation than through litigation to a final decision. So that change is notable and significant, and all of us have seen it. It was born of a collection of phenomena that began to ascend in about the mid-1980s, and that many of you either witnessed or participated in. They included things like the near collapse of the California court system that I know Jeff witnessed early in his career as a mediator, that really, as a practical matter, forced people who needed resolutions to look elsewhere. It included the emergence of mass torts that really cried out for multi-party negotiations and structures to avoid inefficient and redundant relitigation of huge numbers of extremely similar claims. It included the explosion of the cost of litigation, the emergence of well-founded corporate fear of juries and all that they could do, and the emergence of organizations like CPR, by which groups of people who got engaged in disputes started to think in academic and serious ways about alternatives to trials, and that persuaded a large number of corporations to pledge that they wouldn't sue each other before they tried to negotiate or mediate with each other first. So the popularity of ADR has grown, I think, also most of all because people who were skeptical of the value of mediation experienced it and saw, as so many of us have seen time after time, how mediation can yield results that regular litigation and negotiation just didn't achieve. It started, I think, to achieve more ascendancy with multi-party disputes, significantly including things like disputes with multiple tiers of insurers that weren't really susceptible to ordinary conventional bipartite negotiations, and that sometimes required more obviously than other kinds of disputes, the kind of shuttle diplomacy for which mediation is particularly suited. But the evolution is also included bilateral disputes, particularly but not exclusively ones where the disputing parties have business or personal relationships and may want to continue some form of relationship with each other after the dispute is resolved, and the ones in which negotiated resolution can, as they so often do in the mediations we see, involve forms of consideration that are not strictly cash dollars, that may have different value to different parties, that may have human dynamics to them, and that a court would not have the power to consider requiring in any event. So that's sort of where we've been in our evolution, and it's significant and noteworthy and worthy of applause. I guess the second basic proposition I'd offer for your consideration, though, is that ADR and particularly mediation are actually in their relative infancy, with ample basis for predictable continued evolution to a point where they become a far more substantial component of dispute resolution than they currently are. The early signs of the evolution of ADR version 2.0, development from existing practice, but really more than that, kind of qualitatively different and more pervasive, are discernible when we go out looking for them. And they present, I think, compelling reasons for continuing to work to foster that evolution from the perspective that we are really just getting started. For signs of the need for continued substantial evolution of ADR, we need only look at some uncontroversial realities. Let's start with the almost too obvious to be worthy of mention anomaly that resolution of disputes through litigation simply costs too much and takes too long. I don't mean that litigation is merely frustrating, although it may be, but that it is at root economically impractical in the vast run of cases. If you carve out small claims courts, where the court systems in many places have actually done a pretty good job of figuring out how to calibrate the dispute resolution process and procedures to the scale of the dispute. And if you can also cast out the very largest litigations where either the amount in controversy or the principle at stake are so substantial that the cost of litigation is really not a central function or material function of the decision making. And you get to the vast range of other litigations. And for that vast range of other litigations, as a practical matter, the cost of litigating to the point of achieving a final decision, absent some opportunity that exists in some cases, obviously, for a summary disposition along the way, represents such an enormous percentage of the amount in controversy that pursuing that outcome, spending all that resources, that big percentage of the amount in controversy to get to the outcome, especially when a favorable outcome is, of course, always in at least some degree of uncertainty, is simply unaffordable in any practical sense. And one of the painful things is that seasoned lawyers know that, but their clients don't. And seasoned lawyers very infrequently say to their clients, I want you to look forward in the future, a year from now, when I'm having a conversation with you about settlement that is just like the conversation I'm having now, except that you'll have paid me a third of the consideration that you might have, or a half of the consideration you might have to pay in settlement. So do it now. That conversation rarely takes place, even though the lawyers know what the probable fate is. And sometimes the clients do too, and just fail to internalize it. But there's a failure to get arms around the basic unaffordability of litigating to a final result in cases with the medium amounts in controversy. If a case is going to settle, it becomes irresistible for the standpoint of those of us who are trying to think about how to resolve disputes more efficiently, to ask why it makes sense to spend on litigation currency that could otherwise be used to bridge the gap between the parties. As an extreme example, when the asbestos litigation was in its 15th year, one of the ripest litigations in the history of large-scale litigation in the United States, a RAND study revealed that of the dollars that were being spent by companies in dealing with litigation, 15 years in, almost exactly 1/3 were going to the company's lawyers, 1/3 were going to plaintiff's lawyers, and only 1/3 was going to victims. And that's an allocation of 2/3 to lawyers, 1/3 to victim. At that level of ripeness and refinement of the thinking about asbestos litigation, that no objective person taking a step back and thinking what's the right way to run this railroad would agree makes any apparent economic sense. So why don't parties just settle early when they can use their litigation budgets to help them bridge the gap between them? People actually tend to kind of agree on the reasons. And they include beliefs that you hear expressed all the time. The belief that parties can't engage in the dispassionate analysis that is needed when they're in the first flush of adversariality. It's just not ready. They're just not ready. That both parties need to suffer some of the pain and cost of litigation before they're emotionally ready to settle. That initiating settlement conversations early is a sign of weakness on the part of whoever initiates it. That will harm the initiator's bargaining power, or will present the defendant to the marketplace as an easy mark, and thereby encourage others to bring weak cases for a quick, favorable settlements later on. And that the parties need to learn more about these cases through discovery before they can be ready to settle. Now, the fascinating questions arise when we start to consider rigorously how legitimate those undoubtedly very powerful obstacles to early serious settlement discussions really are. And of course, the one you put at the top of the list is, I can't be the one who starts because that's a sign of weakness. How many jillions of dollars of money that could have been used to resolve disputes got spent because of the notion that initiating settlement discussions, being the first one, was a sign of weakness. So the New York State Court System's ADR Advisory Committee that Jeff mentioned, that the Chief Judge asked me to chair, has been studying ADR pilot programs in New York and all over the country over the past few years, and has seen one pattern with really kind of overwhelming consistency. That is the pattern that when courts direct parties to take their disputes to mediation early in a litigation, and I mean early as possible, like the first time the court is aware of the dispute, the settlement rates are absolutely extraordinarily high. As much as early mediation might be expected to result in much lower settlement rates than the mediation after extensive litigation and when the specter of trial is just around the corner weighing on the parties, which is where mediation has been front and center in many of our general experiences, both as advocates and as neutrals. The empirical record suggests that the expectation that you have to wait till then to mediate a result is simply untrue, and that early mediation settlement rates following court referrals to mediation often exceed 50%. Now, similarly, although expectations might be that court directives to mediate are an obvious death knell to the success of the mediation, and even the directives presumptively requiring early referrals to mediation of nearly all cases of particular type. And so the expectation would be that you can't force people to mediate when they're not ready, and that would yield far lower settlement rates than bilateral party-initiated decisions to mediate. The empirical record simply across the board does not bear out that expectation, despite the obvious power of the proposition that a court can't force anybody to seek a negotiated resolution rather than a decision. Court referrals to presumptive mediation apparently are so effective at overcoming those cultural impediments to just getting started that they tend to result in settlements at enormous rates, suggesting that it really isn't the lack of capacity to settle early, but these cultural impediments that actually is the big thing that is holding back early mediations across the board in a much broader category of cases. And by the way, on the discovery point, you know, fascinating exercise. If you're in a meeting where a bunch of advocates are saying, well, we can't possibly mediate early because we need to learn what we learned during discovery, wait a half an hour in the discussion and then say, so let me ask you, old war horses, how often do you think that your perspective on the merits of a case after a year and a half of litigation is within a few percentage points of what your perspective on the merits of the case was 20 minutes after it was first described to you? And of course, the war horses say, oh, I think I've got a beat on almost all my cases in about 20 minutes. And you say, so remember earlier when you said you can't settle early? You actually know, you know a lot about the comparative value of your case. You're rarely surprised. Now, clients, interestingly, take a somewhat different view. They say, at least when they talk to us, litigators are always 80% more bullish at the beginning of cases than they are when they're facing a trial. And it's amazing how that terrible judge or the surprises in discovery have qualified their earlier enthusiasm. I think that's a fault of both lawyers and clients in not being objective enough in assessing the strengths and weaknesses of cases early on. But in terms of just ability to make assessments, lawyers are actually pretty good at it early on. So, you know, so, and by the way, this tendency that I've described of being willing to mediate when ordered to do so is so strong that in a collection of pilot programs just going on in New York, one of the most remarkable pieces of the programs is that the lawyers are besieging the judges behind the scenes. Please order me to mediation, because I can't settle this, but if you order me to mediation, then I can. Suggesting that there's just this hump that has to be gotten over, and that once that hump is over, you actually can mediate at levels that actually you know, implicate changes to the entire structure of your dispute resolution system in a state, starting early. When you see pilot program after pilot program in which automatic presumptive referrals of all cases of a certain type to early mediation result in really quite staggeringly high settlement rates, and I can provide some more details about that, the apparent clear message is that there is an enormous but incompletely recognized and appreciated genuine public appetite for this form of dispute resolution that avoids the problems and that litigation simply costs too much and takes too long. Parties directed to take off their adversary warrior hats and put on the hats of people who have some personal agency in resolving their disputes, instead of going to a succession of meetings in which somebody in black robes does things they don't understand that affect their interests, and as to which they feel entirely passive. Those folks are actually apparently able to shift gears and negotiate peace, even really during the first flush of their anger at each other, with the incentive of saving litigation costs. Operating obviously is a powerful counterweight to all those longstanding cultural sensibilities, viewing early mediation as impractical and doomed to fail. And there's some examples I can give you illustrate, in at least some forms of disputes, prominently including things like matrimonial, family, surrogates court, disputes between commercial parties who are going to have continued dealings with each other. The lawyers who have had experience with such dispute resolution efforts tend overwhelmingly to recognize their advantages over conventional litigation and to favor those processes in advising their clients for those processes' capability to help achieve an affordable and tolerable result, reflecting some important components of personal agency rather than mere passive receipt of court opinions. And I can provide you, fascinating stories about New Jersey, which is the state that is the farthest along in having really truly broad scale mediation at a scale that actually affects how the rest of administration of justice takes place in New Jersey, where initial opponents like the matrimonial bar, who were ferociously opposed to it, now would be rioting in the streets if you eliminated the early presumptive automatic referrals to mediation. It's become a staple of the New Jersey practice. Now, for just one slightly different perspective on what ADR 2.0 looks like, it seems to point powerfully in a similar direction. Let me step out from the vast range of litigations where fighting to an ultimate decision is almost certainly unaffordable, and to the world of court-sponsored mediation, to the relatively rarefied realm of disputes where the amount or principle in controversy is so substantial that the litigation cost is not the driving force, although it's only some force, it seems, for seeing that a negotiated resolution is the right answer. What litigators have broadly seen in this form of major business dispute over recent decades is an almost epochal clash of cultures. On one hand, many businesses and their relevant decision makers continue today, as much as they have for the last 40 years, to view litigation as war and describe it in those kinds of terms. In this realm, the people interviewing candidates to be their litigator unapologetically look for the most aggressive, ready to burden the other side, bullish for the client's position litigator they can find. Often the general counsel's office is pressed in this sort of disposition by the executives whose conduct is being attacked and is the focal point of the litigation, who are angry and defensive and seeking vindication or payback for the offense of the disputes even existing. Litigators tend to have not much difficulty discerning this sensibility in potential clients who have it, and they tend to respond in kind with aggressive litigation strategies and styles and tough talks and assurances about how powerful the client's position is. Lawyers walking into a beauty contest prepared to discuss potential strategies for early negotiated resolutions, as you should always be when you go into a beauty contest like that, have found themselves tucking away those parts of their prepared remarks or regretting having made them, correctly discerning that the prospective clients were busy processing between the lawyers who were appealing to them, who had promised them a categorical victory, and unappealing to them lawyers who seemed to want to help them develop what felt like the terms of their surrender. Now, on the other hand, in this clash of cultures, we litigators have also seen the new and emerging breed of business decision makers who view litigation not as war, but as a familiar form of business problem like other business problems they face, requiring the most skilled people to provide a dispassionate analysis of risk, cost of vindication, consequences of the distractions of litigation, reputational costs and benefits, and probability and timetable for success or failure. These clients want to hire litigators who not only know how to try to win for them, but also can best analyze and give them the best advice on the dispute's strengths and weaknesses, while developing the strongest possible arguments in favor of the client's position, and who could best position the dispute for the optimal prospects for either a win or an acceptable negotiated resolution, recognizing that that's frequently what the true outcome is. Now, these in-house managers tend to embrace early mediation, even if they don't necessarily expect the dispute to resolve early, because they think that mediation will rarely carry downsides and can often help define or narrow the scope of differences or reveal a path to an optimal business resolution that is something broader than just resolving this single dispute between the parties. While those decision makers love to win disputes, as all clients and litigators do, their sense of the institutional cost associated with the possibility of defeat presses them toward rigorous determination of the risk discounted value of their position and attempts to settle on favorable terms without delays in time, in line with that valuation. So now ADR 2.0, this what we see in the future, involves assuming that with the right encouragement, the cultural impediments to disputing parties doing what is ultimately in their greatest economic and personal best interests will erode. And make no mistake, it is clear that parties are often not acting in their best interest, and that these cultural impediments are what's preventing them from doing so. If you believe that assumption, it seems inevitable that early court-sponsored presumptive mediation of disputes will become pervasive. And by the way, what that means, the places where it's pervasive, is that it includes contemplation of mediators who go beyond just being volunteer members of panels, but actually get compensated for their work. Because in order to do this, you need actually thousands of mediators to have a real effect on the court system, even if only as a measure to promote docket control. And sophisticated clients on that other side can be predictably expected, as they continue to become more sophisticated, to embrace ADR as a lower cost and more rationalized, less emotional way of realizing the risk discounted value of their positions. That's not to say, of course, that the right answer isn't sometimes to litigate to a decision. What it is to suggest is that as time progresses and sophistication increases, people will think more rigorously about those issues. Now, it's possible that talk about what ADR 2.0 would look like as a practical matter, but let me stop there and let Jeff ask, or others ask me questions or tell me why everything just suggested is nonsense.
John, that's tremendous. Thank you. The depth of your knowledge and your insights is just wonderful. Let me ask you a couple of questions. Now, you talked about people acting in their self-interest. And clearly people have financial interests, and they also have emotional interests. And the things that satisfy them emotionally may not always be the same things as satisfy them financially. You describe some of those emotional interests in conflict and victory and combat and vanquishing the other side as being so strong that when you pitch clients, you can't even mention the possibility of settlement, and that you can't even initiate those conversations because of fear that the client will think you are weak, or that you're suggesting they're weak. In these court-sponsored programs, with the settlement rate of 50%, which is a lot of cases, what is it psychologically that is going on so that people's psychological investment, their emotional self-interest in vanquish and combat, somehow dissipates or is overwhelmed simply because a court orders them into a settlement discussion? How do we get from denial to anger to acceptance so fast? How does it work psychologically?
So let me suggest a couple of possible explanations. First is, I think, as I've suggested, taking a moment to focus on what is the trajectory of this dispute going to look like, and hear a mediator talk about the trajectory of the dispute, the probabilities of the dispute, and the costs of the dispute, and the duration of the dispute, I think sometimes helps people move into a different sensibility. Second, I think that people have demonstrated, and you've seen it, all of you seasoned mediators have seen it. You've seen the moment when when a parties or a party representatives fight to the death, a switch turns off, and the can this problem be solved switch turns on. It's an exciting moment for in any negotiation or in any mediation. There's body language, there's ways of detecting it, and people are actually able to sort of segregate those parts of their brain, especially when inspired to do so by a good mediator. But a third thing I would suggest is, let me take some of the low-hanging fruit. Matrimonial and surrogates court. We rolled out a pilot program in Westchester Surrogates Court, and the judge, who was sort of uncertain about it.
Johnny, so what is surrogates court?
Sorry,
that term may not be used all over the country.
Fights over guardianship, trust and estates issues, family issues other than custody or child support. But I can use the example of matrimonial court, where the same thing has happened, where we began the program. The judge said, "Okay, I'm going to do this pilot program. Let's send our first 18 cases." And after 2 weeks, he was coming to a meeting of the ADR advisory committee. So he called up and said, "Okay, 2 weeks in, have you gotten started yet?" And they said, "Oh yeah, okay. Of the 18 cases, we referred them all. We've mediated 8 of them. and 7 settled that day, and the 8th one we needed a little more session. We think we're going to settle. And he said, "You had 100% settlement rate? These are the cases that last years in front of me." And they said, "Well, not only we had a 100% settlement rate, what we did was we talked about what was on the parties' minds." Now, all of you who have mediated things that are not just straight commercial things know that it's incredibly frequent that the dispute is not about a tractor. It's about 25 years of resentments based on all these things that you did to me 25 years ago or all those other years, as to which the tractor is just one, the most recent symptom. And so in a mediation, far more than a court position, you can actually get to the 25 years of resentments and not just, as a court is often constrained to do, focus on the tractor. And one of the things that people are finding in these low-hanging fruit disputes that have extremely strong personal dynamics to them, including custody, visitation, child support, other family issues, is that when you mediate the dispute as opposed to litigate it, the recidivism rate is far lower. That is, your typical family court litigant, if you litigate over one of these matters and the court decides it, that person will be back because they still hate the person on the other side. They still feel unsatisfied, and there will be another grievance down the line. But in a mediation, you can actually get to what's really at stake. And frequently, the settlement says, I'm talking to people who are experiencing this. How often have the settlements had components that no judge could ever have engaged on that extend way beyond the particular dynamics of this dispute and go to the relationship between the parties and to reconstruct that? And by the way, that also happens surprisingly often in commercial disputes. We'll solve this by entering into a new contract that redefines our dealings with each other over time. No judge could ever do that. So those, I think those are the particularly low-hanging fruit. There are others, one-time tort cases that don't have that, but they still have that ability to focus people on the economics, on looking forward, on do they really want to fight this the whole way, on just first, in many mediations, it's the first time somebody's heard that there's a concept of a compromise somewhere between zero and the whole thing. And once people embrace that concept, they can go with it. So that's a windy answer, but there's a lot going on.
Well, it's a good answer. Let me explore one other area with you, John, something you mentioned, then we'll have questions from other people in the audience. And you talked about the difference between personal agency and passivity, and that being a distinction between mediation and a adjudication in a court or an arbitration. And yet many of us observe and bemoan what we see in mediation, which is a trend away from personal agency and toward a more passive kind of experience, at least for the clients, and many times for the lawyers as well. And I'm talking about those kind of shuttle diplomacy only mediations, no joint sessions, no direct interaction with the other side, where you basically have a mediator, higher status person shuttling back and forth. They'll pay this, they'll take this. And at the end of the day, you have a mediator telling you, listen, the best deal you can get today is to pay X or take Y, without you or your lawyer ever having laid eyes on anybody from the other side. And frankly, you can't be 100% sure whether the mediator is telling you the truth as to what the other side will take or get. What are your thoughts on what we see as a kind of a troubling trend in many mediations towards this more passive model where personal agency seems to be taking a back seat to almost becoming a kind of arbitration without much due process?
Well, so I guess what I would say is that it's undoubtedly less fun to the mediator and not to exact tears and to have the parties hugging themselves in reconciliation at the end of the day. But I have to say, I've participated in a significant number of shuttle diplomacy mediations in which the conversations were carefully with the mediator were carefully calibrated and may have seemed passive to the mediator. But actually, there was a hell of a lot going on. It was more like the State Department negotiating, where you spend hours thinking about it, and you, at the end of your hours, you end up with one sentence that you communicate to the other side, which the other side then ponders over for hours and comes back with a counter sentence, and you wonder what the hell's going on. And what's really going on is that there's been a breakthrough. You know, I think my personal experience with mediation is that often simply getting the decision maker's undivided attention and moving that person away from all the distractions that reflect the reality that almost everybody, especially any business person, would rather do almost anything with his or her workday than sit around thinking about how to compromise a matter that he or she hates the existence of in the first place. And so you get them in a room, and while you're out trying to get that one sentence from the other people in their room, the lawyers and the decision maker are actually doing something that they often haven't done until then, which is really focusing on the valuation of the case. And there is a lot of action going on that you're not watching, which is why an awful lot of the cases you're describing, where you wonder what the heck has happened, end up at the end of the day, and you feel like all you've done has been a messenger back and forth, but what you've really done is you've created the infrastructure with the parties to work it out between themselves. And it would not have worked without a mediator, by the way, because if they'd gone nose to nose, they would have said, okay, this is what I have, this is what I have, and that would have been it. And somebody would say, okay, we're done for now, I got a conference call, and it'd be another 6 weeks before you got their attention. So the mediation dynamic itself, the structure itself, is conducive to achieving resolutions, even if it doesn't feel like you're the personal transformative element.
John, I must ask one follow-up question before I open it up to others, which is the idea of undivided attention and the effect of our online environment on that. Time was people would have to show up at mediator's office or some law office, and man, you were stuck there. Yes, you had Wi-Fi and you could do a certain amount of other work during the day, but it was sort of like traffic school, right? You had to spend your 8 hours there. You couldn't get if you offered more, agreed to take less, you could go home. But now here we are in the comfort of I'm in the spare bedroom at my house. Everybody looks like they're in pretty comfortable surroundings. People leaving is relatively easy. All you have to do is move your cursor over to that red button in the bottom of the screen. And the idea of undivided attention, I think, has gone down generally in our digital age, and people in different age cohorts, and certainly with us mediating online, the idea of undivided attention is different. Thoughts on that, please?
So one of the most thoughtful pundits in this area I know expressed the view at the beginning of the pandemic that remote mediation would just not be successful for the reasons you identified, and subsequently went out of his way to eat his words, because he said, well, you know, people are able to. Oh, that was you, wasn't it, Jeff? You were that pundit.
Yep.
I think that I think that all of us have the same instincts going in, and have the same empirical conclusion. The instincts going on in was, you know, of course, during that period of shell diplomacy, people have had their iPads and their iPhones and have been checking in on things and been distracted a little bit for years. We would have expected that there was a little bit less focus in remote mediation sessions. Maybe there is a little less focus, but the quantity of focus is degradation does not seem to be enough to make a material difference in the overall success rate of mediations. And that's, I guess, because the fundamental dynamics are still there.
Fair enough. We have a wonderful crowd of people who are also all very knowledgeable and interested, and not so large that they really need to be moderated. So anybody with a question, we've got about 15 minutes left. Please just unmute yourself and ask your question, please.
Hi.
Okay,
Oh, sorry.
Janice, then Anthony.
Oh, okay. Hi. First, I just want to thank you for your insights. I found that very informative. I'm a arbitrator and mediator, like a lot of the folks here, and I really want to get your impression about how we can capture some of these benefits in the arbitration world. For example, the court can order people to mediation, and that gets people past that initial hump, as you said, of not wanting to look weak or be the one that initiates anything that might be perceived as a soft position. Arbitrators don't have that authority. We can't force people to mediate before they do the arbitration hearing. We can suggest it, we can encourage it, we can even hint at things that might be reasonable from our perspective, but we can't actually order it. How can we capture some of the benefits of these systems that you're seeing right now, where the court's really doing a great job of getting everybody to mediation in our arbitration practice?
Well, so you know, arbitration is different, obviously, from court processes as sort of a linchpin for nudging people to mediation in a couple of fundamental ways. You know, one is that arbitration really does, although there are some people who disagree, but I just think they're not right. It costs less. The discovery is constrained. The processes are calibrated. A good active arbitrator avoids waste and delays. Things happen faster, and so the specter of the intolerable cost is not as great. And the second is, however much clients protest differently, people simply fear arbitrators less than they fear juries, and so the need to settle or mediate to avoid a jury trial at the end of the day is not as great in arbitration or as it is in mediation. On the other hand, when you have an arbitration, one of the things you have is two parties who already agreed that they would not adjudicate their disputes in the most conventional way. And you know what I think we in the commercial marketplace are seeing is increasing sophistication of arbitration provisions. I arbitrated a case as an advocate 3 years ago where the amount in controversy was $1 billion, and the contract said that the case must be, that any dispute must be arbitrated. There was actually a mediation process beforehand that went nowhere. It must be arbitrated in front of a retired federal judge who will commit that the arbitration hearing will begin no more than 60 days after the notice of arbitration is filed, and will commit to issuing a decision in writing within 10 days. That will commit to successive hearing days until completed, and a decision within 10 days. So we arbitrated $1 billion dispute in 75 days from complaint to decision. I have another client who, particularly in the sports area, where their collective bargaining agreement says that all arbitrations will take place 5 days after the arbitration commences. The hearing will take place. There's an already identified system arbitrator who handles all matters, and you rip the Band-Aid off quickly. So people who are thinking about arbitration are already thinking about streamlining and being more efficient. At that point, I think trying to get the case to mediation should be largely the role of the litigators, because the litigators know that they've got somebody who's already thinking in flexible ways about dispute resolution, and they should open the client's minds to this other component of dispute resolution. But I think the level of compulsion for it is reduced because of the capacity to get a decision a little more readily and with a little less terror of the associated risks.
Thank you.
Anthony, please.
Yeah, hi, good morning, John. Fantastic talk. And I was just agreeing with what you said about how mediation can actually change the whole environment around a dispute. And when I mediate cases, I always try and do what I call planting a seed, setting this, planting a little seed in the minds of the participants that this might actually work, and setting expectations and kind of getting them in that mindset before we get into mediation. And I should say, by the way, that it'll be I operate out of my little back office now, and it'll be very difficult to drag me out of here into a live, real person mediation in the future. But I actually have a question for you. I've been doing some training lately, and I've been working with the courts in Nigeria. And my assessment of those courts, like, I'll take Lagos as an example. Lagos is a state, and they have a high court, and they have a multi-door courthouse, which is an ADR operation that runs in parallel to the high court, and they have a ton of mediators there. And my assessment is that Nigeria now is where the United States was 10 years ago, in that, you know, mediation was coming up fast, but that a lot of lawyers were still poo-pooing it. And but it's coming along, and I've met so many lawyers over there and non-lawyers who are not only mediators, but they're arbitrators. And that brings me, after a long-winded talk here, to my question. I'm a mediator, I'm not an arbitrator. I know many, many people, including many here, including yourself, who are mediators and arbitrators. And it still seems that even though mediation, everyone thinks mediation is the grand, you know, the magic spell that will resolve any dispute, it still seems to me that people are still very gung-ho on arbitration as a alternative to a lawsuit. And that they believe that still, you know, there's a lot going on in the world with regards to arbitration and arbitration centers. And it seems to be in some cases even still favored by people over mediation, that arbitration would somehow be better than mediation, but and also better than a lawsuit. I was wondering if you had any comment on that whole thing. I'm just confused because I'm not an arbitrator, and I don't see that arbitration is more than a great step down from a lawsuit.
Well, so I think, I mean, I'm personally a huge fan of arbitration as preferable to lawsuits in almost every instance, and as preferable to mediation in some instances. Why is it preferable to lawsuits? I'm amazed at the number of sophisticated clients who, when you say to them, for this important dispute that makes a difference to you, would you rather have the dispute decided by somebody who has been hired by you and your adversary specifically to engage in this dispute, is paid by the hour for the time he or she spends getting familiar with the dispute, who will show up to every hearing that you have in this dispute, having carefully read and thought about everything that you have written about, is not distracted by thousands of other cases on his or her docket? Or would you rather have your dispute adjudicated before somebody who handles literally thousands of cases at once, and who, if unable to resolve this as a matter of law, is going to cause this complicated issue to be resolved by 12 people, of whom about half will have high school educations, the other half, or maybe a third, will have college educations, and the others will not. And to whom you will have to figure out how to simplify and dumb down your story in order to enable them to make the decision. And they probably still won't understand the commercial essence of the dispute. I'm mystified about why somebody would not think arbitration is. And by the way, you can manage with good advocacy and with the right selection of the right arbitrator, manage the cost and duration of your dispute much more effectively and control it much more effectively. And even only hire people who issue fast decisions so you don't have to wait a long time for decisions. To me, arbitration of complex commercial disputes has got so many advantages over mediation. And if somebody says, well, I have a terrible arbitration story, I say, if you got a terrible arbitration story, it almost always starts with a big mistake in your part in hiring a bad arbitrator, when the marketplace of information is sufficiently developed that you can hire only good arbitrators really easily. Now, arbitration versus mediation, you know, I've been extolling the virtues of mediation during this call, and I believe in them very much. But there are times when parties believe absolutely fervently that they are correct and the other guy is wrong, and sometimes they are right. And you know, mediation, for all of its process virtues, leaves out that ultimate point of vindication of the correctness of somebody's position. And you know, so as a lifelong advocate, I'm a huge booster of a system that provides alternatives and that thinks about how you can, in streamlined and efficient ways, pursue the more difficult and challenging road to actually getting a decision, while at the same time having available to you the readier and more commonly utilized, and it should be more commonly utilized course of compromise.
You know, that's absolutely fantastic, and I can honestly say that my perspective has changed as a result of that. So thank you very much, John. I appreciate it.
Thank you. Lakshmi Gopal, please.
Hi, thank you. I was teaching arbitration in a clinical setting in a foreign in a department in Germany that was really invested in foreign direct investment. And so some of my questions will be coming just from that limited commercial foreign direct investment perspective. And I think I'm very keen about arbitration and mediation from a Llewellyn perspective, that you get people who are making decisions at a higher level of expertise in a more targeted way. The two concerns that I have that I would love to see addressed in order to see a more sturdy ADR sector is, one, why do people come out to seek public systems for private disputes? They come out because those disputes are really, really difficult, and they expect some kind of fairness and some kind of predictable systems, right? In a civil law system, they expect the rule to be exactly the same, and the way those rules are applied to different parties will differ. They've agreed on that bargain. So ADR in a place like Germany makes perfect sense to their legal culture. In the US, we've agreed something slightly different that I think is very valuable, and it's part of what makes our legal system so dynamic. We've agreed that we'll use the same rules and we'll try to treat apples like apples. So our judges do something that civil law judges don't do. They try to decide, okay, what are apples, what are oranges, how do we treat apples like apples and oranges like oranges? And so we have a court system that leaves a very different record for the public to be able to judge the jobs that judges do, right? Are they doing that correctly? And what worries me a little bit is, what are we doing in this sector to ensure that the records that arbitrators and mediators are leaving behind, so make sure that we don't convert our system inadvertently into a civil system without some kind of broader amendment, sort of cooperative agreement to do so.
See, I think the movement has been somewhat in the opposite direction. From my observation of international arbitrations, which I've participated in a lot of over the years, you know, if you go back, I mean, I think that the Americanization of international dispute resolution has been staggering. Arbitrations that I did 30 years ago would have no evidentiary hearings. They just have experts and advocates argue. International arbitrators have all, it's like mediation, and once you've had the experience of it, you know what it can do. That view is certainly attached to the art of cross-examination, which was non-existent 30 years ago and is now a standard component of arbitration now. But most importantly, when you talk about the apples and apples, of course, you know, another thing about the American system with its common law approach is that you say, and when I'm thinking about whether this is an apple or an orange, I want to take note that this other person wearing black robes in a different context said it looked more like an apple than an orange, and that influences how I address the apple-orange issue. And one of the things that has happened in international arbitration is the degree to which prior decisions are published in an area where arbitration results never used to be published and are cited as precedent, much in the nature of common law. So that you, on your point about accountability and how, you know, how is there consistency? The answer is that the major international arbitrators have a body of published work about their decisions that demonstrate their points of view, and find themselves saying, I am looking at the result in this prior arbitration that I took this approach in this one, and the way I'm reconciling them as a matter of international public law is as follows. And there is actually something that looks an awful lot like a common law of international public law that is developing. Of course, arbitration is going to be an important component of both international commercial law and international public law, because you have the starting point that nobody trusts the tribunals of one country over another when you have two different nationalities, either in contract with each other or engaging in foreign direct investment as you do. It's led to fascinating questions, particularly in the bilateral investment treaty context, which is where I've done some of my international disputes, of, why should 3 scholars who were picked by the parties get to decide what the international law of blank is and get to decide whether my developing country engaged in an expropriation for which I have to pay billions of dollars? Who the hell are these people? And the answer is that they've got to be people of enormous credibility, quality, and stature, and that the international arbitration bar in the international public law sphere tends to be that. So I hope that's a little bit responsive to your
This is the first conversation I've had outside of Germany, so I'm really happy to hear that, and it answers my questions a lot. Thank you for your work.
Well, John, you have proved yourself to be a person of tremendous credibility, quality, and stature through our conversation in this past hour. It was a tremendous. Thank you so much for sharing your expertise with us. We could go on for a long time. We thank you for being so generous with your time, but our time is up, and so this brings us to an end. Natalie has posted in the chat the food banks that you mentioned, John, feedingwestchester.org and cityharvest.org. So we hope people are able to contribute to those food banks or other food banks of their choice to help deal with the tremendous problem of food insecurity in our society today.
And meanwhile, let me celebrate what it is that you folks are doing and encourage you to keep doing it. You are changing the face of dispute resolution in a way that is an improvement of the world. So thank you for that.
Well, thank you for your kind words, and finally, thank you also for dedicating this hour to the memory of our dear friend and classmate Ralph Gantz. May he rest in peace. And with that, my friends, we are complete. Thank you very
Thanks all.
much.